This is Bloomberg Law with June Grasso from Bloomberg Radio.
The foreign money, the corporate money, the bribery, the years of concealment is a grave breach of the public's trust. Public office is a privilege. We allege that Mayor Adams abused that privilege and broke the law.
Manhattan U.S. Attorney Damian Williams announced the first criminal charges ever against a sitting mayor of New York City on Thursday after unsealing a 57-page indictment charging Mayor Eric Adams with a decade-long trail of corruption. The indictment accuses Adams of accepting illegal campaign contributions and more than $100,000 worth of luxury travel and other perks from Turkish officials and business people in exchange for favors that included helping Turkey get fire department approvals to open a new diplomatic tower in Manhattan despite concerns about its fire safety system. Adams denied any wrongdoing and struck a defiant tone, vowing to remain in office.
My day-to-day will not change. I will continue to do the job for 8.3 million New Yorkers that I was elected to do.
Joining me is Richard Brafald, a professor at Columbia Law School and an expert on state and local government law. Rich, the indictment charges Adams with bribery, wire fraud, conspiracy, and soliciting campaign contributions from foreign nationals. What struck you most about it?
I think the level of facts that the government has put in the indictment means that at least some of the counts, there are 5 counts, my sense is that at least 4 of them are pretty straightforward. And if the government is able to prove in court the facts that they're alleging in the indictment, it will be very hard to defend against them.
What are the 4 that seem straightforward?
Okay. So there are the 2 that are about foreign campaign contributions. One for the 2021 campaign and one for the 2025 campaign. That is flat out illegal. And in fact, when you actually get to the count, obviously there's a long factual backdrop, but those counts are like 2 paragraphs long. It's extremely short and to the point. And if they can show that he kind of intentionally, and with his team, his associates, worked with foreign donors, knowing they were foreign donors, to get them to contribute to his campaign, that's pretty close to open and shut if the facts prove out.
And the other
2 that are pretty close, those 2 just are very powerful, is the federal funds bribery ones, the ones that basically charge him with bilking the New York City matching funds program through various ways. Again, getting the foreign donations, but also other donations where they broke them down and they persuaded the donors to use straw donors so that larger donations were funneled through smaller donors so that they were matchable under the New York City Matching Funds program. That also, again, if they can prove that, that does seem like a straightforward effort on the part of the mayor to defraud the city of New York. And, that's what the federal funds bribery thing is. Is he, in effect, using this for his own benefit? So they certainly have laid out a set of facts that, if they can prove them, are pretty strong. There are no gold bars in this one like in Menendez, but they've laid out a lot of detail.
Williams also spoke about how Adams failed to disclose this free and discounted travel. Where does that fit in?
That's a good question, because I think a lot of what he's describing, of course, are violations of New York City conflicts of interest law, which is not a violation of federal law. I mean, the failure to disclose all these things violated city law. They're giving that as all background, but they're not charging him per se for not disclosing, because that's not a federal violation. I think it goes to the idea that he was hiding it, that he knew that he was getting these benefits and that there was something improper about the benefits that he was getting and that he was getting them in order to subsequently influence his official action. So to me, it's more maybe guilty conscience that he was covering his tracks, because even receiving benefits from these Turkish interests don't necessarily violate federal law. They might have violated New York City conflicts law. But I think they were using it to show that this is part of a broader scheme to get money from these Turkish interests, either to support his campaign and or in exchange for him ultimately doing them favors, official favors.
There are also allegations about a cover-up, including that he created a fake paper trail to disguise some of the travel and perks. They say it's always the cover-up.
Underscores the idea that it wasn't just sloppy, it wasn't just unintentional, that this was all part of a conscious plan.
The businesses circumventing the city's ban on corporate contributions, how does that fit into a federal?
Again, it's, I think, part of this idea that he was using the wires, because this is all technically wire fraud, to defraud New York City. Because again, He was taking those corporate contributions, turning them into individual contributions, and matching them. So in effect, this was, again, part of a scheme to use the wires to defraud New York City, and New York City receives federal funds. That's why it's federal program bribery, 18 U.S. Code 666. I mean, the foreign donations are clearly illegal under federal law. The domestic corporate ones, no. But what they're saying is that he was engaged in a scheme to defraud New York City, because it's not so much that he got the donations as he was leveraging the donations to get matching fund money, and that's taxpayer dollars.
Adams was arraigned on Friday and pleaded not guilty. And we got a hint of the defense from his high-profile lawyer, Alex Spiro, who's represented Elon Musk, Jay-Z, and Alec Baldwin, among others.
There are no emails, text messages, or any corroboration whatsoever that the mayor knew about anything having to do with these campaign donations. The entire body of evidence is one staffer that says there was a conversation. What you have not learned is that that staffer has lied.
Now, that's just the defense lawyer's public take on the indictment. But perhaps the defense will center on, I didn't know what my staffers were doing.
I didn't know. I mean, somewhere along the lines of these were my staff. I didn't know what they were doing. It's hard to say I didn't know this was illegal. I mean, it could be I didn't know this was happening. And certainly I think it's probably the strongest defenses, if there are any, would be in some sense that taking all of these Turkish benefits really, didn't violate any federal law. The government is going to have to link up with all the benefits he got to the fact that he took them knowing they were intending to influence him in official actions. That's the bribery standard, that he knew that he was being influenced, that he took them knowing they were intended to influence his official actions. Frankly, that may be a challenge for the last count. I haven't really spoken about the last count until now, and that's the straightforward bribery, that he took these things, he took all these benefits in exchange for basically pressuring the fire department to accelerate the approval of that building. The challenge there is that he was taking benefits for years and years before. So I think the government is going to have to kind of link up all of the free travel and the free hotel rooms that he got and connect that to the fact that he then did this favor for the Turkish government.
And that's what struck me, that there was really only one major favor that he allegedly did after supposedly years and years of taking the travel benefits, et cetera.
I think that's going to be the hardest count, because you've got the quid and you've got the quo, but do you have the pro? Do you have the linkage? Whereas I think the easiest counts are the foreign funds. Because, if they made the payments and he knew about it or was involved in making that happen, that's all you need to show for the foreign funds. And for the matching funds, it's pretty close. If he knew or he was directing his team to work with these donors to break up their donations into smaller ones and funnel them through employees so that they were all matchable, that's also, a violation of the city law. It connects up with the federal law that makes it a crime, basically, to defraud a government that's receiving federal funds.
Rich, the Supreme Court has been narrowing the scope of anti-corruption laws for more than a decade. Would that line of decisions affect this case?
Yeah, I think that's a legitimate point. So one thing, those will not affect the foreign campaign contributions. So I think those are the ones that's going to be the hardest for him to fight. That should not affect the foreign campaign contributions. For the others, they do require either the showing of an official action, and, that's the question of whether or not pressuring the fire department was an official action. It may be, in that it was trying to affect a government decision, and he was making phone calls to do that. But that's going to be the issue. The issue there will be, did he take an official action, and was it sufficiently tightly linked up to the benefits he received? That one, I think, is going to be tricky. And even the first one about the scheming to get the matching funds, again, is going to have to show that he was kind of showing that he would be influenced in some way by these supportive people. So that's what I'm saying. I think the most straightforward is the accepting of foreign funds for his campaign, the foreign campaign contributions.
And I think it was on the last day of the term that the Supreme Court came down with that controversial opinion, 6-3, with the conservatives, of course, in the majority, basically finding that the federal law that prescribes bribes to state and local officials doesn't make it a crime for those officials to accept gratuities for their past acts.
Snyder.
Yes, bribes.
That's the one about, illegal gratuities. But he hadn't been charged with taking a bribe. So that's not the same thing. they are charging bribery here. The problem in that case is the way the government framed what the man did is first he did the favors for the private companies, and then he went to them and said, give me a no-show job, or something like that. The government didn't charge bribery. The government basically charged accepting an illegal gift. Here they're charging bribery.
You never know what the Supreme Court would do. He could get convicted below, and the Supreme Court could say, wait a second.
Yeah.
There are plenty of those cases, including former Virginia Governor Bob McDonnell, the Bridgegate cases.
Yeah, the Supreme Court has rejected many, many corruption convictions.
Is there a reason why?
It's hard to say. I mean, one argument is these are all involve state and local officials, and maybe the Supreme Court is a little nervous about federalizing the state and local misconduct. Maybe they think it should be better handled by local DAs. I don't know. And sometimes there's a sort of a First Amendment element, but which I think is pretty thin, about, people are trying to influence government all the time. We don't want to make it a crime to be a lobbyist, for example. But I think a lot of the concern is a federalism concern.
There are lots of calls for Adams to resign, but New York Governor Kathy Hochul, she has the power to remove him.
The governor can remove him. The governor has authority under state law to remove the mayor. FDR, when he was governor, came very close to removing Mayor Walker, who resigned while he was subject to the procedure for removal. The state law says very little about the grounds for removal. It gives a little bit more on the process, the little bit of due process that the governor would have to afford the mayor in terms of the charges against him and being able to present a defense. But yes, state law most definitely, very vaguely, but definitely does authorize the governor to remove the mayor.
So many ramifications, and the U.S. attorney just about promised there would be more prosecutions. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next, Coinbase and the SEC face off in court. I'm June Grasso, and you're listening to Bloomberg. Cryptocurrency exchange Coinbase and the Securities and Exchange Commission faced off in the Third Circuit Court of Appeals this week, as Coinbase is trying to force the SEC to create new rules that would govern digital assets. Appellate judges Thomas Ambro and Stefanos Bibas questioned the SEC's refusal to engage in rulemaking and its approach of regulating by enforcement.
It almost looks as if, to an outside observer, as if you're going after the platforms in a way that will crush the industry without really getting into rulemaking.
It is true that this case is not directly about due process, but there are some serious notice concerns with, we might hit you with serious civil penalties, but we won't tell you what will trigger the civil penalties.
Although Judge Ambro did acknowledge how new the field is.
In this area, which is, since 2008, 2009, it is so new, I can see why a lot of regulators or people considering regulation are saying, we better go slow on this one. This is a new world.
And Judge Bibas asked Coinbase's attorney, Eugene Scalia, what's the end game here?
Your Honor, we are asking now that they be ordered to proceed directly to a rulemaking. We think they have had more than enough opportunity to answer Coinbase's workability concerns.
That's an extraordinary remedy. What would we say has to be in such a rule?
Joining me is securities law expert James Park, a professor at UCLA Law School. Jim, tell us how this ended up before the Third Circuit Court of Appeals in Philadelphia.
Coinbase filed a petition with the SEC asking it to write rules relating to crypto, and the SEC denied that petition. And so Coinbase filed a lawsuit saying that the denial was arbitrary and capricious. That's a standard that's typically applied in administrative law. And the district court initially denied that petition, and now it was appealed to the Third Circuit Court of Appeals, and they heard the oral argument on it.
The lawyer for Coinbase, Eugene Scalia, and I have to say he did sound a little like his father, the late Justice Antonin Scalia.
Is that right? Wow.
So he told the three-judge panel that the SEC had provided no explanation for denying the request for rulemaking, and Coinbase is complaining about the SEC's regulation by enforcement.
I think their main argument is that the SEC has publicly said to various crypto organizations, come in and register. And their argument is that this is disingenuous because there is no real practical, pragmatic way for the these associations to register and provide disclosure. And this reflects the decentralized nature of blockchain projects where you are essentially creating a network community that runs itself without any central manager that is in charge. And unlike a corporation where you have a corporate entity and a centralized management team that can collect disclosure about the corporation, put it into SEC filings, and file it, in theory, you do not have that with crypto projects. And their argument is that, these crypto projects associations cannot come in and register because there is no central issuer that can provide disclosure. And until we have a set of rules that tells us how this works, we simply cannot move forward.
Is it often that agencies are asked in court or anywhere to make rules? Because usually you think the less rules, the better for those who are being regulated. It's
true, and it's just an interesting example where the industry is demanding a certain amount of certainty, and because this is a industry that is still emerging, is on the border in terms of legality, I think that Coinbase and others in the industry believe that a set of rules or a statute would confer a certain amount of legitimacy on crypto, because if you regulate it, it must be permissible in some instances. There are certainly cases where you see corporations in the industry asking for more specificity with respect to administrative rules. That is something that we do see from time to time. Whether or not that happens in a formal petition for rulemaking, I think that is much less common, and that this is an unusual case.
Let's talk about the SEC's position and the Howey test. They're saying basically, look, we don't need to make any new rules. We have rules here.
That's their argument, is that we have an established legal framework. We have the Securities Act of 1933. We have the Howey test that says that investment contracts are securities in certain circumstances. We have shown you through various administrative releases and enforcement actions how we think the Howey test applies to crypto, and in some circumstances they are securities. Once something is a security, we have a set procedure where you have to file a registration statement if you want to sell those securities to the general public. If you are an exchange that has securities trading on it, you also have to register with us as well. And I think they would say, you want this to be this decentralized organization where no one is in charge, but the reality is that there is usually a central group of individuals who basically start these crypto projects. They are developing the code, they develop the applications, they reach out to investors, they promote it, they promise high returns, they keep a lot of crypto for themselves. So if the price of the crypto goes up, they make a lot of money, kind of like a controlling shareholder or insider of the organization. Those organizers could certainly provide disclosure. They could, certainly be responsible for filing a registration statement, and that, has not happened. I think that's what they would argue in response.
A couple of the judges did acknowledge that this was a new area and maybe you'd want to proceed slowly. But then you had some sort of accusations against the SEC. One judge said that it looks like you're going after platforms in a way that would crush the industry without getting into rulemaking. And another said, it's not that you're not interested in the area. It's just that you're interested in picking off wrongs without giving higher level guidance. It's hard to measure which way it's going, but it did seem like they had a lot of hard questions for the SEC.
I suspect it's very possible, and it's maybe probable, that these questions reflect a certain skepticism about the SEC's position. And, the idea that the SEC is crushing the crypto industry is probably accurate to some extent. Now, the SEC would say, well, the reason we are closely regulating this industry and preventing these schemes from flourishing and selling and distributing crypto to a lot of members of the public is because we're concerned that a lot of these projects are fraud and that investors are going to lose a lot of money. And if we don't keep an eye on it, we're going to be blamed. People are going to ask us, what were you doing? And given past experience with, FTX, for example, and some of the other scandals that we've seen, there is probably good reason to be very careful about allowing wide-scale distributions of crypto to public investors in the United States. So I think that the judges, though, I think that probably reflects a sincere questioning of the SEC and its regulatory approach. It has moved sometimes in contradictory ways, in ways that are ambiguous, and you've seen some shifts in their policy where sometimes they are open to passing rules, other times they seem to not be open to that, and so they have kind of shifted their position here and there. The SEC would say, well, this reflects the difficulty of keeping up with this innovative technology and understanding exactly what's going on, and we were very careful at first. We didn't crush it right from the beginning because we just wanted to see how it would evolve. And over time, with experience, we now understand there are some real problems and dangers. There have not been a whole lot of useful applications of crypto that we know of, other than its use as a currency to make transfers of money that would not be permitted under other federal regulations like banking law. And that's sort of the main thing that it has been used for. So I think that, the questions do reflect a general frustration at the SEC and maybe, the reality, I think, that the SEC is not interested in creating an easy path for these crypto firms to flourish. So I think that is probably accurate.
So do you think that that's the reason why they're not making rules? Because it seems pretty clear under Gary Gensler that they consider digital assets as securities.
It's complicated. I think that there are a lot of really difficult issues here, and there are no clear answers as to what sorts of regulations you would pass. And a lot of the sort of issue of whether a digital asset is a security or not is very fact-intensive. So, to give you an example, sometimes crypto is purchased for consumptive reasons. I want this digital coin because it gives me access to this service. Sometimes it's purchased because I want to make money, because I'm speculating, I'm investing in this network. And if it's investment, it's more likely to be a security. If it's more for consumptive means, then it's less likely to be a security. How do you write a rule that tells us when something is more of a consumptive purchase and something that is for investment? It is very difficult to do so. And, that I think is part of the reason why the SEC is wary about getting into this process of trying to draw these distinctions. It would much rather look at these situations case by case and bring an enforcement action and maybe litigate it before a judge, as opposed to trying to answer some questions that may not be answerable. And I think that's a reason why they are not essentially writing these rules. And I do think that FTX and the crypto winter, as they say, is something that has really affected the SEC's view of crypto. And if you write rules that permit crypto firms to sell widely to the public and there are significant frauds, then the SEC will get blamed for that too. So it may not be in their interest to go forward with extensive specific rules.
So at one point, one of the judges said to Coinbase's attorney, well, what rule would we tell them to make? I mean, do they have to say specifically or just say SEC engage in rulemaking on crypto?
Well, I don't think the Third Circuit at this stage would order the SEC to engage in rulemaking. I think probably the best possible result for Coinbase, which I think is feasible, is that the Third Circuit will say that your denial was arbitrary and capricious because it didn't explain enough as to why you are not making rules. And so I think the SEC will still get a chance, even if it loses this case, to articulate the reasons for denying Coinbase's petition. But I think just the procedural setting of this particular appeal is not one where even if the SEC loses, they're going to be writing rules on crypto, a month after the decision comes out. I think what would happen is that they would look at the petition again and they might deny it again but give more extensive reasons. That's one possibility. On the other hand, maybe they will change their mind. It's certainly possible that they could change their mind and say, hey, we will write rules, but I would be surprised if they did that. So we're a long ways from the SEC being required to write rules relating to crypto.
And so we'll keep seeing this being litigated, especially at the district court level. Thanks so much, Jim. That's Professor James Park of UCLA Law School. Coming up next, J&J tries bankruptcy for a third time. I'm June Grasso, and you're listening to Bloomberg. Johnson & Johnson first filed for bankruptcy in North Carolina. Then in New Jersey, both cases were dismissed. Will the third time in Texas be the charm? J&J is trying to resolve tens of thousands of lawsuits that allege its talc-based baby powder caused cancer. And it says it has the support of 83% of claimants for a roughly $8 billion settlement. But lawyers for claimants who oppose the settlement are asking Houston bankruptcy judge Christopher Lopez to transfer the case back to New Jersey. Joining me is Anthony Casey, a business and corporate bankruptcy professor at the University of Chicago Law School. Tony, tell us why J&J ran into trouble with its bankruptcies.
So this goes back to 2021. Johnson & Johnson, their consumer subsidiary, had been the defendant in suits alleging ovarian cancer and mesothelioma being caused by mostly their baby products line, although there's some other products involved, containing talc. And so there was a bad judgment around that time, and this leads to the decision in 2021 to file an entity into bankruptcy. And this is when people start talking about the Texas two-step. Now, the allegation is that there's asbestos in the product, and so what they looked to was a precedent where a few other companies had filed what had become pejoratively known as Texas two-steps. The idea of the Texas two-step is, step one, you divide the defendant entity into two entities, one that houses the kind of ongoing business and one that houses the liabilities. Step two, you put the liability company into bankruptcy. And if you describe it that way, a lot of people get worked up and say, oh, look, that's a fraudulent transfer. Everyone kind of skips over. There's an intermediate step, which is you also include a funding agreement. And the funding agreement says when the entity goes into bankruptcy, the new asset company guarantees to make available the value of the assets that were available before the division. As I said, this kind of pejoratively became known as the Texas two-step. Where does that come from? Well, the statute under which you divide the company in the first step is the Texas Divisional Merger Statute. So Johnson & Johnson, really Johnson & Johnson Consumer Inc., JJCI was called, that company does the divisional merger, creates the new JJCI and the LTL. LTL files in the Western District of North Carolina. There's a funding agreement that says all of the assets that were available before the division are still available. The value of those are available and guaranteed for whatever liabilities end up. And in case those assets lose value, the parent company, J&J, guarantees to make good on any change in value. That was bankruptcy number one.
So that was transferred to New Jersey, where the bankruptcy judge refused to dismiss the case. But tell us what happened when that was appealed to the Third Circuit.
The Third Circuit says, no, you should have dismissed the case. Nothing to do with the Texas two-step other than the funding agreement provided value. And the Third Circuit says there's too much money available here for you to claim that you need to be in bankruptcy. You're too solvent. You're not in immediate financial distress. So that case gets dismissed. A couple hours after the dismissal becomes effective, you have attempt two, and they file bankruptcy again, and this time in the District of New Jersey. So what they do, following kind of the logic of that Third Circuit opinion, is they reduce the amount of money available, but they maintain enough so that we're still a solvent entity, so that we're not going to underpay creditors, is the way that Zay, the second debtor, framed it. And they file bankruptcy again, and this time in the District of New Jersey. This time, the bankruptcy judge says, well, I'm looking at the opinion before, I'm looking at what you did. There's still enough money available that you're not close enough to financial distress, so I'm going to have to dismiss this case. That goes on appeal to the Third Circuit. The Third Circuit says that's right, affirms.
And so J&J filed the next bankruptcy outside the Third Circuit, which is the only circuit that has that financial distress rule, and also changed its strategy.
So in the third round, Johnson & Johnson's announced, rather than file a bankruptcy and then see what happens, we're going to get the vote first. We're going to go out to all the claimants and try to build a settlement. Now, the goal of the first two bankruptcies was to be in bankruptcy and then build a settlement that creates a fund that allows claimants both past and future, to come and collect against that fund. This time around, they're like, well, let's get everyone on board on the fund first. So they do what's called a prepackaged bankruptcy. So we're going to get a vote of all the potential claimants, and we've got to get a supermajority to get a settlement through. Now, during that time, they apparently determined that they were going to use bankruptcy to settle the ovarian cancer talc claims, but not the mesothelioma claims. So they separate those off. And they have a vote among the ovarian cancer claimants over the summer, and they now say they have roughly 83% of the potential claimants voting for a settlement. And the settlement was kind of laid out here. If you vote for this, here's the plan we're going to put before the bankruptcy court. We'll have a vote when we go in. Are you on board with this? So what they did then was another divisional merger, and they filed in Texas this time with the vote in place, the plan drafted in line, hoping to get the kind of approval through the Texas bankruptcy court.
So the opponents of this, some of the lawyers representing claimants, say that J&J is trying to game the system because it's trying to get bankruptcy protections that are meant for companies that can't afford to pay their debts. Do you agree with that?
No. So this has been the debate from the beginning with the question of whether or not bankruptcy is the right place for mass tort claims to be resolved, whether or not the Texas two-step is a positive or a negative. Now, one thing to note is that Chapter 11 corporate bankruptcy has always been a tool for resolving collective action problems among creditors where their actions could destroy value. And the way that they can destroy value is you ultimately get a race to the courthouse. And so if you think about any of these mass tort cases, you've got tens of thousands of claimants. Some of them are going to get a zero recovery. Some of them are going to get $1 billion recovery. And what happens is that we don't know when these claims, particularly with asbestos, will end because asbestos shows up years later. And so you have a decades-long future of litigation that's costing, at one point I think they said it was costing $1 billion a year to litigate these cases. And that's destroying value. Now, the Third Circuit in its first opinion said, look, you're Johnson & Johnson. There's enough money for this to go on for quite some time without it causing any problem. Now, that won't always be true, right? If you have 100,000 claims that are worth millions of dollars each, that'll bankrupt any company in the world. And what's really going on is stakeholders are losing value in the current world because there's just endless litigation. If money runs out, it'll be the case that the first to come win and the later to come lose. And bankruptcy has the only mechanism in our legal system that can get parties to a global resolution that says, here's the money available. Let's stop destroying value. And that benefits the debtor, but it also benefits the creditors because it gets the money put aside and available sooner rather than later. So if you're one of the current 80,000 claimants or so, when is your trial going to happen? When is your settlement going to happen outside of bankruptcy? And if you're someone who doesn't even know that they're sick yet, the timing of when the value gets put aside for you is years or decades away. So bankruptcy, the way I look at it, is intended to solve those kind of problems.
The attorneys for the talc claimants who oppose the latest settlement proposal are trying to get it transferred out of Texas. And the Justice Department's bankruptcy monitor, the U.S. Trustee's Office, had filed in New Jersey to get it transferred to that state.
And that already failed, right? So the New Jersey motion, I didn't quite understand why you're trying to file it there. There's lots of legal problems with trying to get the New Jersey court to take the case from Texas. Partly, there is a bankruptcy rule that says if a debtor with a pending case files somewhere else, the court with the pending petition can bring it in. But the New Jersey court dismissed the case, right? There's no petition pending there. So one, it's not clear the court could take it, but two, the court has the discretion not to, and it already denied that motion saying, for now I'm not taking the case. Okay, so then the right place to bring a venue transfer motion is in the court where the case that you want transferred is pending. Like that's what the statute says. That would be the Texas court. But what's the argument for transferring it? So where should this case be? The New Jersey case has been dismissed. Texas actually is the first and obvious place to file for a company that has use the Texas statute to structure itself in this way where we simplify the bankruptcy. And to think about it, the simplification, the mesothelioma claimants aren't voting for a bankruptcy settlement. the ovarian claimants are. And so the value of the separation, just to use an example, is we're going to put the ovarian claimants into the bankruptcy process, which overwhelmingly they voted in favor of, and we're not going to put them as mesothelioma claimants. We're also not going to put all the other creditors of the operations of the business. We're not going to have them subject to the bankruptcy, and we're not going to have them able to step in and make objections. So we're really simplifying it so that the only way that a plan gets confirmed in the Texas bankruptcy is if there is a valid vote of a supermajority of these claimants. No one else can affect that. It's really just about whether or not they want this settlement. And that's the simplification that the Texas two-step allows.
I can understand why the lawyers who want to try their cases want the bankruptcy case moved out of Texas. But why did the bankruptcy trustee want it moved to New Jersey?
So I think the trustee's office has taken a negative view of a lot of the mass tort bankruptcy structures. Maybe they're of the view that, you need to truly be insolvent. This is partly why they appealed to the Supreme Court in the Purdue case. They had a policy view that you're not supposed to use third-party releases in mass tort bankruptcy cases. I'm a little surprised in their motion in New Jersey because the office tends to be kind of textualist and formalist, and if you look at the rule, I don't see how the New Jersey court had the power. And so they were asking it to do something, I think, that would be not formalist, beyond the power of the statute, which is not the way I normally think of their positions. That said, I think that they view themselves as the watchdog of bankruptcy process, which I think is a good thing, but they have a view that what large companies are doing to reach mass tort settlements in bankruptcy is problematic. I think that's an incorrect view, but I think that's what's driving this. Their views are put out there even when they conflict with the majority views of the claimants. And that was true in Purdue for sure, and it seems to be true here as well. They're just like, but this is the way it should be done, and that's why they want it in New Jersey. I mean, the claimants are everywhere, so it's not clear why New Jersey is better for a claimant than anywhere else. Now, maybe their view is you've already been dismissed in New Jersey. You should stay there. You shouldn't be able to try to change things. Like, companies' circumstances change over time, so how long do they think they're bound by the fact that they had a ruling in one court at one time? Like, are they bound into infinity to never file anywhere ever again? That can't be right. So I'm not totally sure the theory that the trustee's office has, but it seems to be that they don't like what's going on in a kind of a vague sense.
And there'll be basically nothing going on until October 11th, while Judge Lopez considers whether the bankruptcy will move forward in Houston. Thanks, Tony. That's Professor Anthony Casey of the University of Chicago Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.